And so our third and final speaker to close out our program is Joseph Milowich of InterJurisconsult. InterJurisconsult is a Canadian boutique law firm specializing in immigration law with a particular focus on business immigration, providing immigration services to all types of businesses and industries from around the world in respect of all parts of Canada. InterJurisconsult was founded by Joseph Milowich, a Canadian immigration lawyer who is also a registered migration agent in Australia and a licensed immigration advisor in New Zealand. Joseph, please take the floor.
Thank you, Nathaniel, for the introduction and for hosting this second day of the Congress focusing on Canada. I would like to welcome everyone attending this event today. I would like to thank all members of the organizing committee, all speakers and presenters, and everyone who kindly assisted in organizing this Congress. I would like to acknowledge and thank our sponsor, Scotiabank, for supporting our Congress. I would also like to thank our interpreters who have been providing simultaneous interpretation between English and Spanish throughout the interpretation channel, which you can access by clicking on interpretation button at the bottom right of the screen. Nathaniel has been kindly introducing everyone during today's Congress, and I would like to take this opportunity to say a few words about Nathaniel. Nathaniel Balakumaran is an associate lawyer at Mills Mills LLP, a Canadian law firm which co-organized this event. Nathaniel practices in the area of business law, advising private companies as well as charities and non-profits on both corporate and commercial matters, including corporate restructuring, contracts, transactional work. In addition to his business law practice, Nathaniel practices in estate law, particularly in the area of estate planning and administration. Once again, Nathaniel, thank you very much for hosting and moderating this event. Yesterday's part of our Congress was focusing on Central America. And if you had a chance to observe yesterday's speeches and presentations, you may be very excited about the opportunities that exist in Central America. Today's part of our Congress is focusing on Canada. And after hearing a welcome speech from Canadian Ambassador James Hill, and from the partner of Mills Mills LLP law firm, Denise Robertson, as well as from today's earlier presenters, Taras Kulish and Sabina Mexis, both lawyers at Mills Mills. Many of you may also be excited about opportunities that Canada can offer. And you may wonder how business people, professionals, and their families, family members may get temporary and permanent residence in Canada. I'm glad to inform you that despite global COVID-related challenges, Canada remains open to mobility and business and professional persons and their family members to Canada. But of course, global COVID-related challenges have added another level to complexity to such mobility to Canada. And now I'm going to give you an overview about the mobility opportunities that opportunities in Canada, business people, professionals, and their families may have. And with that, I will go straight to the presentation. Nathaniel, please let me know if you can see the presentation.
Perfect. Looks fantastic.
Perfect. Thank you very, very much. Okay. So this bit is about InterJurisconsult law firm. I'm the principal lawyer at this firm. Nathaniel has already given you the background, so we'll go straight to the presentation. Today, I'd like to cover the following topics. First, I'll start with the relevant departments and agencies in Canada that deal with migration and border control in Canada. I'll talk about temporary entry to Canada, permanent residence in Canada, as well as inadmissibility issues, and also we'll cover obtaining immigration status in Canada for family members. And then I'll be happy to answer any questions and answers, questions that you may have. There'll be a questions and answers session at the end. Now, Nathaniel mentioned that there will be a panel discussion, so maybe you can reserve all your questions if you wish to the panel discussion, and then my colleagues will be happy to contribute on any aspects that relate to their area of practice. So under temporary entry to Canada, I'll be covering business visitors, global skill strategy, labor market impact assessments, LMIAs, work permits, international mobility, and under permanent residence, I'll cover federal programs and provincial programs. So what departments exist in Canada that relate to immigration and to border control? Immigration, Refugees, and Citizenship Canada, IRCC, previous acronym was CIC, Citizenship and Immigration Canada, generally is responsible for immigration matters in Canada. When a person wants to submit an application for temporary residence or permanent residence, IRCC would normally adjudicate on that application. The exception to that would be when a person appears at the border and makes an application there. Typically, the application would be handled by the CBSA officer from Canada Border Services Agency. These two agencies split. They used to be part of the same organization, but they split into two, and Canada Border Services Agency typically focuses on enforcement and border control, and Immigration, Refugees, and Citizenship Canada, obviously, as the description provides, focuses on immigration, refugees, and citizenship. The third department that deals Employment and Social Development Canada, ESDC, formerly also known as Service Canada, focuses on authorizations in the context of mobility context, on authorizations for employers to obtain a pass to for their prospective employees to get to apply for a work permit. We'll talk about that in more details in just a moment. And then immigration departments and provinces and territories. So in the past, the federal government used to have complete authority over all immigration matters. And then at some point, the government of Quebec approached the federal government and asked them to share that responsibility by suggesting that Quebec knows very well what the province of Quebec needs in terms of the type of immigrants that the province would like to welcome. And there was an agreement made between the federal government and Quebec to allow the province of Quebec to have certain say and responsibility over selection of immigrants that are destined to that province. Then almost all provinces and territories had some type of agreement with the federal government in sharing the responsibility for selection of immigrants to provinces and territories. And so this responsibility now is shared pretty much across Canada, but there are federal programs that exist where the federal government decides on all matters, and there are some provincial and territorial programs that exist where the territories and provinces handle certain parts of the process of selecting immigrants, and then the federal government would typically focus on such matters as admissibility and verification. Let's talk about business visitors. As the name suggests, people who would like to come to Canada for business purposes, just to visit, would potentially be admitted to Canada as business visitors. There shouldn't be any intent to enter labor market when people come to Canada in this category, and they should not be seeking gainful employment in Canada. Such people their activities should be international in scope, and there is a presumption that the primary source of workers' remuneration would be outside of Canada, and that the principal place of foreign workers place of business foreign workers employers would be located outside of Canada, and that accrual of profits of foreign workers employer would be located outside of Canada. In terms of examples, of what can constitute a business visitor purpose. So such things as buying goods, services for an entity, attending meetings, seminars, conferences, trade shows, and exhibitions in Canada would all fall within the activity that can be described as business visitor activity in Canada. So, for example, if these congresses were to take place in Canada physically, and there would be a number of attendees coming from abroad, these people would normally declare their intention to enter Canada as business visitors. Examples of business activities that would not fall under business visitor category would be such activities that would require provision of services in Canada, and when there would be competition in any way in the Canadian labor market, and any activity that would require remuneration from a Canadian entity. So those activities are not part of the business visitor activities and would not fall under that category, and a work permit in most cases would need to be sought and applied for. There are some exceptions though. So I'd like to talk about a global skill strategy exemption. These exemptions from obtaining a work permit, and a few words about work permit. In a lot of cases, overwhelming majority of cases, a foreign national who is in Canada would not be allowed to work in Canada unless they have a authorization. What that authorization would be normally would be a work permit. In some cases, some categories of temporary residents would be exempt from work permits. In the context of business visitors and professionals, we're going to talk about highly skilled and researchers, and majority of those exemptions would be in the first category. So under the global skill strategy, why this first of all came to be, the government recognized that Canada is competing for top talent internationally, and so it was decided to enable foreign Canadian businesses and talented professionals from around the world to be able to have an easier and faster access to Canada. And so as part of this strategy, there is an exemption from applying for a work permit. And so the categories of executive, managerial, and professional levels, National Occupational Classification, NOC O and A, would fall into that description. National Occupational Classification, NOC, is the classification of various occupations. It's an official classification in Canada, and most of the occupations would have certain description in that National Occupational Classification list. There are some occupations that are borderline and not easily categorized, but for all intents and purposes, when making an application, one would have to pick a National Occupation Code in most cases, and trying to see what the most appropriate code would be when there is a borderline occupation. The entry of people under this exemption can be for 15 consecutive days every 6 months, or for 30 consecutive days once every 12 months. Then the researchers category, in recognition of significant needs of Canadian educational institutions and research institutions, it was decided that researchers could come to Canada for a period of 120 days once every 12 months to perform research at Canadian publicly funded degree granting institutions or affiliated research institutions. In terms of the other types of global skill strategy applications, I'd like to talk about the LMA's labor market impact assessment, exempt work permits under global skill strategy, and the ones that would be based on work permits, LMA-based work permits. We'll talk about LMAs in a moment, but generally speaking, as I mentioned earlier, There is ESDC, also known as Service Canada, that makes decisions on these LMIAs, on labor market impact assessments, that would allow employers to hire foreign workers if exemption doesn't apply, exemption from work permit, from LMIA in this case, to apply for a work permit. The beauty of this type of application is that the processing time is relatively fast, 2 weeks. In order to qualify for that, the employer must submit a complete application. The application would have to be in the NOC codes O or A, and that's for the LMIA exempt work permit. And they would submit this application through the employer portal for an offer of employment. And then the prospective employer would apply for a work permit outside of Canada. It needs to be mentioned that International Experience Canada stream is not part of this fast processing timeline, and so they would normally require more time to process applications under that stream. In terms of LMI-based work permits and the global skills category, there is a global talent stream for LMIA, and foreign workers would need to submit an application to SDC under the Temporary Foreign Working Program to apply for LMIA approval under the global talent stream, and that application also would take 2 weeks to process. Again, that's provided that the application is complete. These days, however, there are some delays, and the government generally is trying to comply with 2 weeks processing, but there could be some delays, as mentioned by the government, due to COVID challenges and pandemic. And so for this, two LMI-based work permits need to be submitted outside of Canada. So more about labor market impact assessment. So global talent stream, as I mentioned, 2 weeks processing, 10 business days for the LMIA to be processed and hopefully approved. There are two categories, category A and B within LMIAs under global talent stream. One is that is as a result of a referral from a designated designated partners, and the other category is for specific positions. In terms of designated partners, there are a number of institutions such as Business Development Bank of Canada, Council of Canadian Innovators, there are Global Affairs, Canada's Trade Commissioner Service, Invest in Canada, and many other referral designated partners that can refer a candidate to this particular program. In many cases, if not in most cases, employers would be applying using the B category under of the global talent stream. And there is a list of occupations. Many of them are related to computer science and other technical occupations, such as computer engineers, information systems and analysts and consultants, software engineers and designers, and so on. And so if the occupation falls is listed on that list, then the employer requires to fill such position, they can use global talent and benefit from fast processing of the application. If a global talent stream is not suitable because there is no referral from designated partner and the occupation is not listed on the occupation in demand list, then there is a default type of LMIA. Again, if the work permit is not exempt from LMIA, then the employers would have to follow a more strict process, and that a general LMIAs, if we may call them as such, fall under high wage stream and low wage stream. And in the context of this LMA applications, employers would have to engage in recruitment efforts and advertise the position for a required period of time, normally 28 days, but recommended a longer period to demonstrate both genuineness and significant need. But sometimes it's not, the positions might be too urgent, and the employers might not be able to wait if they can't fill the position with the Canadian citizen or permanent resident. In the context of this general MIA, there would be a transition plan unless the employer applies, creates a permanent position, and if it's anticipated that the foreign worker will transition to permanent residence at the end of the temporary resident stay on LMA-based work permit. In the context of global talent stream LMAs, I'd like to also mention that there is a requirement for employers to take from themselves a number of commitments relating to labor market benefits, and they would need to commit to such things, for example, as creating co-op or internship opportunities for Canadian citizens and permanent residents at their businesses for a certain period of time, normally over a period of a couple of years, and in potentially in increments. Then make investments in training and skills, and increase their capacity. And essentially, the employers would need to provide rationale for hiring a foreign worker and how this will help them improve their business and be more competitive and more successful, and what labor market benefits there will be for Canada if as a result of hiring this foreign workers. In terms of LMIA regionally, LMIA process, it is the same for every province except for Quebec, with the added requirement in Quebec that in addition to LMIA, there is a requirement to submit a concurrent application for Quebec acceptance certificates, CAQ, and it's submitted to the Quebec's Ministère de l'Immigration et de la Francisation et de l'Intégration, MIFI. Now, I would like to say a few more words about work permits. So LMIA-based work permits for business professionals. Again, employer must obtain positive LMIA through either the global talent stream or through the any other application stream of the temporary foreign worker program from Service Canada or ESDC, as it's also called. Prospective foreign workers must submit a work permit application after employer has been able to secure LMIA for the position that the prospective foreign worker would occupy, and that LMIA would form the basis for the work permit application that the prospective worker would be submitting, either in Canada or in outside of Canada, depending on the substream of the LMIA. LMIA exempt work permits for business professionals. So again, a job must fall under National Occupation Code O or A or B. Those are higher skilled levels. There is also level C and D that are lower skilled occupations, and they're not suitable normally for business professionals. There are some other categories that can be suitable for other types of LMIAs, but we are covering mostly business and professionals today. Employer must submit an offer of employment through the employer portal, and that's again in the context of LMIA exempt work permits. Prospective employer must submit a work permit application after that. So in terms of LMIA exempt work permits, there are a number of categories that fall that wouldn't require LMIA, and as you can now appreciate, LMIA is a significant commitment on the part of the employer, and if the employer can hire a foreign worker without resorting to LMIA process. Of course, most employers would prefer such option. So to hire a foreign worker without having to go through the LMIA process, the employer can consider the international agreements as the basis for the work permit application. As the employer, of course, the application would be submitted by the foreign worker, but the employer would have to submit a job offer through the employer portal in our FCC system, and then provide a special code to the foreign worker that the worker would use to submit to include in the work permit application. In terms of relevant agreements, so as you may have heard from Canadian government officials that were making presentations during our two-day Congress, there are a number of free trade agreements that Canada signed with many different countries, and including some countries in Central America. The access to these agreements for the foreign workers would depend on citizenship in most cases. In some cases, it will also be available to permanent residents, but we're not going to go into all those details, but just for information, keep that in mind. And that's the reason why I mentioned some of the other agreements that are not specifically designed for Central America, but some people in Central America might have a dual or multiple nationalities. For example, there could be a person that has a passport of Costa Rica or Panama and also have a passport of United States. It may be possible for such person to apply under the CUSMA, a new agreement that Canada, United States, and Mexico signed. And under that agreement, there are some mobility provisions. Then there is general agreement on trade and services. Most countries in the world would be part of that, and nationals from those countries could also use mobility provisions of this agreement. Then there is also Canada-European Union Comprehensive Economic and Trade Agreement, CETA, and citizens of European Union can use this agreement to come to Canada using the mobility provisions of that agreement. Then comprehensive and progressive agreement for Trans-Pacific Partnership that has a great number of countries, and including Canada, Australia, and there is some discussion that United Kingdom would potentially be joining this agreement, but there is about a dozen countries that are part of that agreement as well. Canada has bilateral agreements with that have mobility provisions with Chile, Colombia, Panama, Peru, and Korea. Once again, Canada has multiple bilateral agreements, but these particular agreements have mobility provisions that can benefit foreign workers to come to Canada using those provisions. Quite often, the foreign workers and employers considering hiring foreign workers would be looking at intercompany transferees, professionals, technicians, traders, and investors. Out of all of these, probably intercompany transferees, such categories as executive, senior management, specialized knowledge workers would be most common. But again, a lot of professionals are using some of the other exemptions in the context of exemptions from LMIA and the context of other free trade agreements. Very commonly, that would be the situation with CUSMA, formerly known as NAFTA. Next on the list is Canadian interest. Canadian interest would be another way for foreign workers to apply to use the exemption from LMIA. There are exemptions under significant benefits for entrepreneurs self-employed. Those are typically either at the federal or provincial level. And then there are categories for intercompany transferees, executives, senior managers, functional managers and specialized knowledge workers, and also emergency repair and repair personnel for out-of-warranty equipment, television, film production workers, and francophone mobility. Francophone mobility is a very useful category. All of them are very useful, and employers heavily rely on many of them. But what's particular about the francophone mobility is that it's more broad in terms of the range of occupations. And so this is the category that is for people, for foreign workers, prospective foreign workers that would like to work in any part of Canada except Quebec, because this program is designed to strengthen the francophone communities across Canada. And you may know that Canada federally is a bilingual country officially, English and French being official languages of Canada. There is also a province of New Brunswick that is officially bilingual at the provincial level. And Quebec is predominantly French-speaking province. Other provinces, but also provide services in English to some extent, but it's predominantly French-speaking province in most cases. Other provinces and territories in Canada, even at the provincial level, would have some services that would be available to French-speaking people. And this particular program intends to increase the number of French-speaking francophones across Canada outside of Quebec, so that those services can be maintained, and that the francophone community outside Quebec can be thriving as much as the anglophone community across Canada. In terms of permanent residence, so business people and professionals might want to initially enter Canada on a temporary basis, and that's the fastest way in most cases for them to come to Canada, start their business, or fulfill any important need for at any particular business entity in Canada, for example, and bring maybe their family student with them, and stay and work in Canada. Sometimes people might want to apply for permanent residence and then start their business venture in Canada. We'll talk about those options as well, but quite often people start with temporary residence in Canada and then transition to permanent residence, and that's probably in most cases when it comes to business professionals who come initially to Canada on a work permit. So in terms of types of programs, there are federal permanent residence programs and the provincial programs I earlier talked about, shared responsibility between provinces and territories and federal government in some aspects of selecting foreign candidates for immigration to Canada, or for yes, under different types of programs. And so under the federal programs, we have a startup visa. Startup visa was very successful when it was just at its initial stage, and the processing time was extremely fast, and there was a significant interest in it, but there was a lot of expectation that it would be very, very successful. At this time, it's probably the victim of its own success, as it's oversubscribed and the processing time is extremely long, unfortunately, for those people who are applying through the startup visa. The intention of this visa was for innovative businessmen or innovative professionals or creative minds to set up business in Canada, create jobs in Canada, and globally compete from Canada. Generally speaking, it was hoped that sort of Microsofts and Apple companies could be created in Canada and grow from Canada. And there are a lot of success stories but unfortunately the processing times are quite long these days. And for this reason, many people are seeking entry to Canada through other immigration categories. For example, intercompany transferees is one of those categories that people might use if they have if they fulfill the requirements. Now, in terms of requirements for the startup visa program, there should be a qualifying business. They need to get a letter of support from a designated organization. There's a huge list, a long list of the organizations that can support in that. They need to meet language requirements, and they need to have some settlements funds, money to settle in Canada for their initial stay here. The amounts for one person is just over 13,000 that they need to prove that they have for their settlement purposes in Canada. Now, in terms of self-employed, that's another category that that would require a very long processing period. And for that reason, again, a lot of people are reluctant to use it and trying to find another opportunity to enter Canada, even if they wanted to run their business on their own. Typically, the categories that fall within self-employed at the federal level would be farm workers or people in arts and sports that have achieved international recognition. And those who are in farming sector would need to prove that they have the ability and experience to set up a successful farm or run a successful farm in Canada, own and operate. The most used, I would say, category for permanent residents in Canada for business professionals these days, or the system, I should say, is express entry system. This system has been in existence for since, I believe, 2015, so about 6 years, just over 6 years now. And there are three programs there under this system: skilled worker program, Canadian experience class, and skilled trades program. The reason why it's very attractive is that the processing times pre-COVID pandemic period were quite fast. Right now, they're still relatively reasonable, but there are certain delays. And the skilled worker program has been put on hold quite often because during this pandemic, because probably the government didn't want to have more people coming to Canada during this pandemic period. But the program is still there, and if there are still remaining applications processed, they are being processed. The Canadian experience class is for people who have experience working in Canada. And the skilled trades program is for people who have skills that are not in the that are listed specifically on skilled trades list. In terms of the way the system works, a person would have to create a profile in the IRCC's system. That's the government department responsible for immigration, and then wait for invitation to apply for permanent residence. How quickly a person can apply for such for permanent residence? Well, it depends on how quickly they can receive the invitation. There is no specific time when the invitation can be provided to such person. Typically, there were rounds of every couple of weeks for Canadian experience class, and in the old days, so even for skilled worker program, and also for some subcategories for provincial nominees that would also be invited, or in tandem with the federal with the provincial government process for such a process. But mostly we're talking about Canadian experience class that's currently very active to allow people who are already in Canada generally to have Canadian work experience to settle in Canada. Once the invitation has been received by the foreign worker, the foreign worker would have to, by the prospective immigrant, the person and his or her family can apply to submit the application for permanent residence. And then the processing time would be anywhere from, say, 6 months to a year to over a year, depending on luck and many, excuse me, and some other factors, depending, of course, on the complexity of the actual application. In all cases, it's always best to submit a complete application so there is no back and forth, and not to jeopardize the application, as incomplete applications can be refused. In terms of provincial programs, there are business programs for various types of business owners and executives, and they can apply through these programs. The main problem with these types of programs is that they take significant period of time to be processed at the provincial and territorial level, as well as at the federal level. And so if there is a possibility of getting a one-step process that is shorter, potentially cheaper, and potentially easier, then of course that would be preferable. But in some cases, people prefer these options, as other options are not viable for one reason or another. So there are business programs, there are programs for skilled workers, skilled trades, and some other programs. Of course, there are family sponsorship programs, but this is not part of today's discussion, and so I'm not going to focus on those. So in terms of the provincial programs, once again, the applicant and the employer typically would be submitting applications to the province or to territories for approval, and then upon approval, the federal government would be then considering the applications for permanent residence. And at the end of the process, if everything's successful, federal government would be issuing immigrant visas and confirmation of permanent residence to such immigrants. In terms of the process, so there are requirements for every type of category to come to Canada, but inevitably, regardless of the category, there are inadmissibility matters that need to be considered by the applicant and by the businesses and prospective employers in Canada. And that is inadmissibility because they can create significant obstacles for people's entry to Canada. In this context, there are ways to overcome certain inadmissibility matters. For example, DUI, driving under an intoxication, would be, render someone to be inadmissible to Canada. And in such case, depending on circumstances, depending on how long ago this event took place and what happened after, this person may be eligible to apply for one of the two types of applications, temporary resident permit and criminal rehabilitation. And this is, so temporary resident permit is generally for people who inadmissible on all sorts of grounds. If issued, a person would be allowed to be in Canada or to enter Canada as a temporary resident. If a person is issued a long-term temporary resident permit, then such person would be also able to apply for a work permit. And quite often, if a person is applying for a work permit, and if inadmissibility is an issue, they would need to also submit an application. They may have to submit an application for temporary resident permit, not in all cases, depending on number of circumstances, but it is a factor that needs to be assessed, and proper type applications need to be submitted in order to maximize the chances of success. Criminal rehabilitation deals with inadmissibility on a permanent basis. So that's not necessarily just in the context of permanent residence, but in terms of having finality to the inadmissibility for criminality to Canada. And this inadmissibility can be on the grounds not just of any event in Canada, but anywhere in the world. Same thing with temporary residence permit. It's relating to factors that cause inadmissibility for whatever reason anywhere in the world. And so temporary residence permit once again resolves the inadmissibility on a temporary basis. And for such period of time, a temporary residence would be issued, and criminal rehabilitation would resolve inadmissibility for those particular grounds on a permanent basis. In terms of time, processing time, temporary residence permit is normally much faster, especially for people who can apply who are from visa waiver countries, and there is significant need for their presence in Canada for justifiable reason. Those type of applications can go through very, very fast potentially. In some cases, they need to be adjudicated at the consulate and not at the border, even if they are from visa waiver country. It depends on the officer's decision and the complexity of the matter. And in terms of criminal rehabilitation, in most cases, unless it's a deemed rehabilitation, and even then, because of the processing, border processing issues, this time it's best to submit an application for adjudication to the Canadian officials outside of Canada, unless the person is already in Canada. In terms of family members, so business people and professionals would like to quite often bring their family members with them to Canada, and they can bring their spouse, common law partner, and minor dependent children. In terms of the type of authorizations that they can get for temporary residence would be visitor status. It can be authorization to enter Canada as a visitor, or a person from a country that citizens of which would require a visitor visa to come to Canada would need to apply for a visitor visa. And then a worker category, again, a person would need a work permit, and if they need a visa to come to Canada, would need to apply for a work visa. And the student category, same thing, persons who are from visa waiver country could potentially accompany the main applicant, a family member who's applying as a business worker or a professional worker, and they would be applying for a study permit if they're from visa waiver country, potentially at the border. And if not, they would need to submit the application through the Canadian visa post of the Canadian consulate embassy abroad. In terms of processing times, that would depend if they are applying together, and if yes, then the timeline would depend on the processing timeline specific to that particular work permit application. They would all be able to apply all together. If they are applying separately, for example, a foreign worker comes to work in Canada and then the family would follow sometime later in the future, then they would be submitting their own applications, and how they can apply that would depend on their citizenship and some other circumstances. In terms of permanent residence, again, the principal applicant may submit an application for the whole family. And this can be the foreign worker that comes to Canada as a business person or as a professional, but the spouse or common law partner could also potentially qualify on their own, and or for the family, if they meet all the requirements for a particular category. And so sometimes the spouse or common law partner would be the main applicant, and the foreign worker would benefit from the application as the family member of such applicant for permanent residence. And I believe this is all. So if there are any questions, I'll be happy to answer them either now, or if we're going to proceed with panel discussion, then I will be happy to contribute to that discussion, answer questions that would be posed to the panel. Thank you very much, everyone, for joining our event today. Once again, thank you for staying this long. I hope you've learned a lot and that you're all considering at least Canada as a place to start a business or expand your business to Canada and make investments in Canada and potentially move to Canada with or without your families. With that, I'd like to turn to Nathaniel, who can lead us to the next step if we're moving to the panel discussion. Thank you once again.